This is Barry Zalma speaking for Claim School Incorporated's blog Zalma on Insurance. Today we're going to speak about why a general contractor, not being a lawyer, should avoid litigating as if he were, and why the general contractor had no standing to sue. Steven Hester Hall appealed from an order granting the defendant's motion to dismiss Hall's claims for breach of fiduciary duties, insurance licensing violations, bank fraud, insurance fraud, breach of the implied covenant of good faith and fair dealing, harassment, and unfair and deceptive trade practices. He did this in Steven Hester Hall versus Brunswick Plantation property owners, September 6, 2022 decision of the Court of Appeals of North Carolina. Hall wanted to build a house without the bond required by the Community Association's regulations. Hall is a general contractor and the CEO of Eco Lakes Construction, LLC. Eco Lakes owns real property in Calabash, North Carolina, in the Brunswick Plantation and Golf Course community. Defendants are the Brunswick Plantation Property Owners Association, the Community Association Management, the Property Management Company for the association, Greg Mayol, the Community Association Manager for the community, and Cathy Six, the Administrator for the Architectural Standards Committee for the association. The contract's Performance and Master Deportment Agreement is a contract between the Architectural Standards Committee and a general contractor on a construction project in the community. The Master Deportment Agreement requires the general contractor to provide to the association a $5,000 bond to be held as security for the performance of the construction project in accordance with the community governing documents, the Brunswick Plantation Architectural Plan and Residential Design and Construction Standards, and the amended and restated Master Declaration and Development Plan for the Brunswick Plantation. Hall submitted plans to construct a home on the property, but did not provide the $5,000 contractor compliance bond required by the Master Deportment Agreement. Defendants declined to act on the plaintiff's construction proposal until he provided the bond. Plaintiff sought a bond waiver, and the defendants declined to issue the waiver. Plaintiff again refused to provide the bond, and defendants directed plaintiffs to cease construction on the lot. On 23 April 2021, Plaintiff Hall sued and filed a motion for temporary restraining order and a motion for preliminary injunction against the defendants. The trial court denied the motion for a temporary restraining order. In an amended complaint, Hall alleged breach of fiduciary duties, insurance licensing violations, bank fraud, insurance fraud, breach of the implied covenant of good faith and fair dealing, harassment, and unfair and deceptive trade practices. Defendants moved to dismiss the amended complaint. Hall moved to amend his complaint to add additional causes of action and an additional defendant, and an objection to defendant's motion to dismiss. The trial court granted defendant's motion to dismiss on 29 July 2021. The court, in issuing its opinion, advised that when dealing with a motion to dismiss, the court must liberally construe the allegations, and the court should not dismiss the complaint unless it appears beyond a doubt that the plaintiff could not prove any set of facts to support his claim, which would entitle him to relief. The caption of plaintiff's complaint indicates he is bringing action for breach of fiduciary duties, etc. The suit indicates only that Hall is challenging the propriety of the contractor compliance bond as required by the Master Deportment Agreement. Hall failed to state a claim upon which relief may be granted under some legal theory, according to the court. In order for a court to have subject matter jurisdiction to hear a claim, the party bringing the claim must have standing. Standing means that the party has a sufficient stake in an otherwise justiciable controversy to obtain judicial resolution of that controversy. Every claim must be prosecuted in the name of the real party in interest. A real party in interest is a party who is benefited or injured by the judgment in the case. A lack of standing may be challenged by motion to dismiss for failure to state a claim upon which relief can be granted. The court noted that Hall appeared to argue that the amended and restated Master Declaration and Development Plan for Brunswick Plantation was unenforceable because it is ambiguous and is a restrictive covenant on the property. Plaintiff does not own the property, nor does he have a protected legal interest in the property. Accordingly, he lacks standing to bring the action. In the alternative, the trial court dismissed plaintiff's case because plaintiff did not have the authority to bring suit on behalf of Echo Lakes. In North Carolina, a corporation like Echo Lakes must be represented by a duly admitted and licensed attorney at law and cannot proceed pro se, acting as its own attorney. Here there is no indication that plaintiff is a licensed attorney. Rather, plaintiff's a general contractor and the president and CEO of Echo Lakes. To the extent plaintiff purports to bring claims on behalf of Echo Lakes, he may not do so. The trial court's order dismissing plaintiff's complaint was therefore affirmed. In my opinion, this case is an example of the misuse by a litigant of allegations of insurance fraud and the tort of bad faith, which had no relationship to the problem. To avoid buying a minuscule $5,000 bond, which might have cost him all of $500 in premium, Hall filed suit alleging the planned community where he wanted to build a house, accusing the defendants of multiple torts and the crime of insurance fraud because they insisted he obtain a bond to protect the community. He had no standing and was, if anything, attempting to bludgeon the defendants and cause it and them to retain counsel and defend this spurious claim. The Court of Appeal refused to honor his scheme and should have sanctioned him for bringing the case without standing. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who wants it at www.zelma.com/blog. If you found this video and blog posting to be of interest or useful to you, please inform your friends and colleagues that they too can sign up and receive a free subscription to Zelma on Insurance. They might also want to consider subscribing to my Substack and to my locals community. Thank you for your attention.